Thank you. I will ask first a very simple question. RA number 6770, the Ombudsman Act, provides, and I read, Section 22, investigatory power. The Office of the Ombudsman shall have the power to investigate any serious misconduct in office, allegedly committed by officials removable by impeachment, for the purpose of filing a verified complaint for impeachment if warranted. Question. Under the law, Ms. Witness, as Ombudsman, you can investigate any serious misconduct allegedly committed by the Chief Justice. Since an impeachment trial is now ongoing, the only purpose for your present investigation should be to file a verified complaint for impeachment by December of this year. Here is the question. Do you intend, if the defendant is acquitted, to file a second complaint for impeachment this year?
Your Honor, it is the House which determines whether, on the basis of the data it receives...
I am not asking about who decides. I am asking about a provision in the Ombudsman
Yes.
Act which provides, Section 22. The Office of the Ombudsman shall have power to investigate, etc., for the purpose of filing a verified complaint for impeachment if warranted. That is your job. So is that job being undertaken now by the Ombudsman with its present investigation? Since there's no point investigating, an impeachment trial is already ongoing. Therefore, under Section 22, your sole purpose could only be to file a second complaint for impeachment after the one-year ban provided by law. Therefore, I'm asking you the question, do you intend, if in this first impeachment trial, the defendant is acquitted, do you intend to file a second impeachment complaint against him after the one-year ban?
Madam Senator, if the charges presently being investigated by the Office of the Ombudsman are not included in the impeachment charges, then I don't see any reason why there should be no chance to file another impeachment complaint.
I'm sorry, I don't get the question very correctly. The answer very correctly. Is your answer a yes or a no? Is that a yes? You are
for the purpose
intending
of
to file.
filing
Yes,
an impeachment complaint,
that's right.
if that is warranted after the investigation, conclusion of
Thank
the
you.
investigation.
Yes, that is what the law says. For the purpose of filing a verified complaint for impeachment if warranted. If you
Yes.
think it is warranted,
Then we
your
discuss.
only purpose will be to file a second impeachment complaint. Isn't that so? Is that a fair question?
If it's warranted, we will.
All right, thank you. That is the only question. So we are placing the defendant on notice that even if this court acquits him, he can expect a second impeachment complaint by December this year. For that is what the law says. The Ombudsman cannot investigate unless it is for the sole and only purpose of filing a verified complaint for impeachment if warranted. You are so warned.
May I
Thanks,
be allowed to
Counsel.
speak, Your Honor?
That is for the presiding officer too.
May I please be allowed
You may answer.
to qualify
Yes.
that nothing will prevent the Ombudsman from filing for future proceedings if warranted.
I take that as a yes. I am a student of constitutional law. Let me now go to certain questions of constitutional law. This is going to be a little tedious, but still it needs to be raised. I am very intrigued by the worldview of the Ombudsman on the relationship between a constitutional provision or provisions on the one hand and the provisions of laws passed by Congress on the other hand. I have to start with the fundamental principle, and I hope you'll all forgive me, that the Constitution is a written limitation of the powers of state. It is not a written grant of state power. 4, the fear always is that government might turn tyrannical against its own citizens. In fact, reflecting this fear, our Constitution specifically provides in the Declaration of Policy in Section 1, sovereignty resides in the people and all government authority emanates from them. I draw from this background the conclusion that if there is any doubt, the doubt must be resolved in favor of the rights of the citizen and against the powers of the state. With that preface, let me now proceed. First, I would like to recite the constitutional provisions of the powers of the Ombudsman, which appear to be very plenary, infinite, and wide-ranging. These are the provisions of the Constitution in Article 11, and I will qualify them by saying that Congress passed a law called the Ombudsman Act of 1989, virtually copying the constitutional provision. Under Section 13, the Office of the Ombudsman shall have the following powers, functions, and duties. 5, request any government agency for assistance and information necessary in the discharge of its responsibilities, and to examine, if necessary, pertinent records and documents. Section 33, duty to render assistance to the Office of the Ombudsman. Any officer or employee of any department, bureau, or office, subdivision, agency, or instrumentality of the government, including government-owned or controlled corporations and local governments, when required by the Ombudsman, his deputy, or the special prosecutor, shall render assistance to the Office of the Ombudsman. Finally, Section 15, Paragraph 8, the powers of the Ombudsman. Administer oaths, etc., including the power to examine and have access to bank accounts and records. These are the broad language employed by the Constitution and virtually copied in the law passed by Congress, the Ombudsman Act of 1989. But in juxtaposition to these broad constitutional powers of the Ombudsman, we also have certain laws passed by Congress, which includes, naturally, both the House and the Senate. One of them is the Foreign Currency Deposit Act, which provides, Section 8, secrecy of foreign currency deposits.